5 seconds to go. Start. It is alleged that the original defendant went back upon his promise and refused to accede to the request made by the respondent plaintiff. Stop. Para. In the circumstances, on or about 17th October 2005, the respondent plaintiff filed the suit. Stop. The original defendant filed a written statement denying the allegations in the plaint. Stop. In the written statement, the original defendant denied the execution of any agreement for sale of the sued property for consideration of rupees 15,10,000 as alleged. Stop. Para. The original defendant has categorically stated that he did not agree to sell the suit property to the respondent plaintiff as alleged and that he did not receive any advance on 11th November 2002 as alleged or on any other date. Stop. It is the case of the appellants that there was no concluded contract to sell the suit property. Stop. In the written statement, it is also pleaded that in any case, the respondent plaintiff was never ready or willing to perform his part of the contract. Stop. Para. The respondent plaintiff examined 3 witnesses and the original defendant deposed as witness on his own behalf. Stop. By a judgment and order dated 30th November 2010, the trial court decreed the suit and directed the original defendant to receive the balance sale consideration of rupees 15 lakhs and execute the sale deed in favor of the respondent plaintiff. Stop. Para. All the issues framed by the trial court were answered in favor of the respondent plaintiff. Stop. The trial court found that the respondent plaintiff was ready and willing to perform his part of the contract, and thus entitled to the relief of specific performance. Stop. The relevant part of judgment of the trial court is set out herein below, para, quote start, but I already discussed that the plaintiff is a businessman and he is having sufficient means to pay the amount to the defendant rupees 15 lakh also deposited into court. Stop. The amount has not shown in exhibit A4 to A6 is not the ground for denying the prayer. Stop. The plaintiff is also ready and willing to perform his contract and in view of the above discussions, the plaintiff is entitled the relief of specific performance and possession of scheduled property. Stop. Accordingly, I answered the issues numbers 4 and 5. Stop. Court close. Para. By the impugned judgment and order dated 30th October 2017, the High Court upheld the judgment and decree passed by the trial court, holding that the respondent plaintiff had always been ready and willing to perform his part of the contract. Stop. The relevant part of the impugned judgment and order reads, para, the letter dated 11th November 2002 has been marked as Exhibit A1. Stop. In Exhibit A1, period has been fixed for execution of a registered sale deed. Stop. The consistent case of the plaintiff is that despite of repeated demands, the defendant has not come forward to execute a sale deed in favor of the plaintiff and therefore, a legal notice has been issued. Stop. Exhibit A2 is a copy of the legal notice dated 13th February 2003 and the same has also been received by the defendant. Stop. After receipt of the same, he has given a false reply notice dated 10th March 2003. Stop. Since on the side of the plaintiff, necessary documentary and oral evidence have been let in, it is easily discernible that the plaintiff has always been ready and willing to perform his part of the contract. Stop. Therefore, the fourth contention put forth on the side of the appellant's defendants also goes out without merit. Stop.